Hello and welcome to Legal Time here at Connaughts. My name is Ahsan Malik. I'm a solicitor here. We will be talking about legal issues today, answering some of your questions on the live chat, and just discussing some important recent cases which have come to light, which some of you may be interested in. Here with me today I have Awais Javed, a solicitor here at Connaughts, and we'll be discussing a few of your questions and queries. So one of the topics of today's conversation is in regards to long residence. We were discussing earlier on, weren't we, Awais, in regards to long residence, the people who have been here for a very long time and just about to complete their 10 years legal leave to remain in the UK, but they're still outside the 28-day time in which to make an application. So how would one go about that?
This is something we have discussed in our previous programs. By the way, good evening everyone. Welcome once again to our bi-weekly program. This is a topic we have discussed previously in our program as well. There was a recent change when it comes to exceptions to lawful residence under the immigration rules. It was under section 39E. This exception, this change came in July, 6th of July last month.
Oh wow.
Previously, ideally, if someone has not finished their long residence, and let's say their appeal rights are exhausted or their application is refused and their long residence is broken, they had 14 days to make in an application. And once they have made that application and that application is granted, their their long residence will not be broken. Also, if that application is refused and they have made another application within 14 days of that refusal, under section 39E previously, before 6th of July, they could still continue their long residence if second application is approved. But on 6th of July, what government has done is they have said that you only have one chance of making an application now within 14 days of your appeal rights being exhausted or your leave being curtailed or finished, or let's say your application is being refused. Now the problem in that is, so for example, scenario you have mentioned, if someone has had their appeal rights exhausted or application refused, which was an in-time application, and their long residence stops, and it stops more than 28 days before they qualify for their 10 years long residence, what would they do in that case scenario? Well, the only option they have is to make an application within 14 days.
Sure.
One thing that is clear is that application, whilst it is pending, it does not extend what we call their 3C leave. So there is no doubt about that. But there is an argument to make that because this is an exception to long residence, which is section 39E, any application made within 14 days of the leave being finished, if that application, no decision is made on that application, let's say until they have finished their 10 years in the UK, then this should be considered as something which should be part of their valid continuous stay in the UK. I'm not using the terminology valid leave to remain in the UK because technically they don't have any leave at that stage, and making an application does not extend your leave. But because there is an exception within the immigration rules for overstaying for 14 days, that exception is yet to be seen under the light of any specific case law. How will it be looked at? My opinion, I think if application is made within 14 days and whilst that application is pending, this should be considered as part of continuous stay in the UK, and if the decision is made after 10 years are finished, Home Office should grant them leave to remain, indefinite leave to remain, if other requirements are obviously fulfilled in terms of their life in the UK, test English language, and there are no previous breaches, etc., and the general grounds of refusal. So I would say that do make an application within 14 days, and once you have finished your 10 years on that application, do write to the Home Office. Putting them on notice or providing them this information that you have finished your 10 years
while
now,
the application
whilst the application is pending, do not vary that application or do not make another application, but just send further submissions explaining that now you have finished your 10 years and your application should be considered under 10 years long residence, which is 276B.
Yeah, so just simply informing them should be sufficient in order to just make sure you can let them know that you've completed everything.
Exactly, yes,
right.
and then that's it really.
Okay, great. In regards to long residence, in regards to children, let's come to that. So if you're a child who's born in the UK and lived in the UK, how would one go about in terms of, in terms of getting nationality?
For that, if child is born in the UK and lived in the UK for, you said, continuous 10 years?
Continuous
10
okay.
years. If child is born in the UK and lived for 10 years, then child qualifies for citizenship, but child needs to register. So the child needs to make an application. I think it's Form T, to make that application. So use that form. Procedure is pretty straightforward. Child can make that application and will be granted citizenship. I think the most important question is, if child is been granted citizenship, then can parents on the basis of that child who is a British citizen now make an application, obtain leave to remain if they don't already have one? Answer is yes, they can. They can make an application for leave to remain. They can even go into the premium service, and we have done dealt with these type of cases regularly. Child is a British citizen. If parents are primary carers of that British citizen child, then there is no reason, unless there is an adverse immigration history, which will affect the decision maker, which obviously will have influence on the decision maker, negative influence. They should be able to get leave to remain in the UK even on premium service. So I would strongly recommend that if your child has lived in the UK for 10 years,
do they need to have leave to remain, that child, throughout that 10-year period?
They don't. No, it's a very good question. No, they don't. Children, they don't have to have leave to remain for their long residence to qualify for citizenship. If it's an adult, obviously they can apply for indefinite leave to remain, but they have to be legally living in the UK for those
but
full
for
10
children
years.
it is different. They just need to be born and living here for 10 years, and then they can obtain nationality. And then obviously, if they've got family who haven't got leave to remain or want to use that child's British nationality to obtain leave to remain, they can do so.
That's right.
Okay, we do have some questions coming in. I'm just trying to look for some relevant questions. I'm not sure if you wanted to just answer any of them.
I would be happy to. I just want to put the... Okay. Yeah, sure. Go ahead.
Some of the questions that we have are not necessarily applicable to what we're discussing.
That's fine. We can answer those questions because...
Okay, so one person's asked in regards to just a generic question. They've submitted an FLRFP application which has been under process since last July. They just want to know how long will usually the Home Office take to give an answer. So usually the Home Office will always say that their standard service time is 6 months from the date of submission of application to make a decision, unless they've initially told you from the outset of when you've submitted the application that they're going to take a little bit longer to make a decision on the application. That's pretty much correct, right?
That's right, yes. I mean, 6 months is the standard time frame for any application. If they take longer than 6 months, generally they write to you explaining why it may take longer than 6 months. If they haven't written to you, then obviously you can write back to them after 6 months, inquire what's happening.
Going on.
Exactly. And even if they have written to you, you can still have a right to ask them questions as to why there's a delay, if you think there shouldn't be any.
Yeah. And that's something that we could definitely help them with in terms of like contacting the Home Office. And if they want a quick response, how would they go about it?
Well,
there's different.
They can send them a pre-action notice as well if they think there is a detriment to their life. For example, if they had urgently had to travel somewhere, or there is any other issue. For example, if depending on what application it is. If they think there is really a serious issue and they need to have a decision first, and there is no reply from the Home Office, my advice would be to write to them first. If not, then obviously another route can be taken, which could be a bit stricter. So you can send them a pre-action notice and say, obviously they will come back to within 14 days with that. But that is not something that should be taken as a first course of action.
Sure. Okay. Always make communication via writing. Someone just asked a question into what we were discussing. Say if a child was not born in the UK but has lived here for 10 years, I don't think that would apply to obtaining nationality?
No, unfortunately,
No.
to qualify for citizenship, child has to be born in the UK.
Mm.
But if child has lived in the UK for 10 years and not born in the UK, then obviously child can apply for indefinite leave to remain on the basis of long residence, like we've discussed. But unfortunately, child won't be able to apply, or depending if child has leave to remain already. If child doesn't have leave to remain already, then child will have to make an application under 7 years policy, so they will get 2.5 years, and then from that point onwards they will have to finish their 10 years because before they can obtain citizenship, or indefinite leave to remain and then citizenship.
So the child needs to be born in the UK, otherwise if they're not, then they have to go for alternative routes. Okay, someone's asked in regards to what we were just discussing at the beginning of the show. If I applied within 14 days of my first application refusal, will I be able to get a right of appeal for ILR application? If yes, then lawful residence is continued, means I'll get ILR? Question. This is from someone who's left a comment on the...
Sorry, can you repeat that question?
So if I applied within 14 days of my first application refusal, will I be able to get a right of appeal for ILR application? If yes, then lawful residence is continued.
Well, this person hasn't mentioned which type of ILR application we're looking at. If this is an application under the human rights, so long residence, for example, so 10 years long residence, or otherwise, or under 276B, for example, for leave to remain, then it's a human rights application. If it's a human rights application or a human rights claim you have made, then that claim can always be certified as long as Home Office can show that if appeal right is given, then no judge will allow that appeal. So basically they will have to satisfy that test that this appeal will bound to fail. If that appeal bounds to fail, then Home Office can certify any human rights claim. Doesn't matter whether it's for indefinite leave to remain or otherwise.
Okay, we're going to move on to a few other topics. I see some questions which I'll put forward to you a little bit later on. So we want to discuss an important case that recently came about in regards to obtaining nationality and proof of paternity. Do you want to talk a little about that case?
Yes. It's an admin court case.
K versus SSHD.
Yes, K because it's a child, so obviously name is there's an anonymity direction on that. Basically, ideally what used to happen was if a child, or still happens, is if child is born outside of the UK or even within the UK, and parents are based citizens, child is a born based citizen. Similarly, if child is born outside of the UK and parents are based citizens and they obtain any of the parent has obtained their citizenship other than by descent, then any child born outside of the UK under Section 3(1) of the Nationality Act will be a born-based citizen. So a child can simply make an overseas passport application for travel purposes. The child is a based citizen. But there is a section under Nationality Act 1971 or 81, I think it is, and Section 50, subsection 9A. What it states is that the father of the child is the one mother is married to at the time of the birth of the child. So in cases where you have a child, let's say outside of the wedlock, but the father of the child is a British citizen, obtained citizenship other than by descent, but the mother was married to someone else at the time of child's birth, that section would bar the nationality of that child. So that child, even though father is a British citizen, should have biological father should have qualified under Section 3(1) for citizenship, but because of the application of Section 59A, child would not be able to qualify. Now this case is very interesting because the court has decided that this applicability of this section is not in line with the Human Rights Act. So it infringes human rights of that child enjoying rights as citizen, and also not in line with this the today's I would say norms of the society. We have children in these case scenarios born overseas where maybe mother wasn't married to the father of the child at that time, but they were only they were not granted citizenship just because at the time of the birth mother was married to someone else. Now, based on this case, it is made very clear that it's not in line with with how the society is developing, and also the Human Rights Act. It is yet to be seen whether it will be incorporated into the Nationality Act or not. But because it's an admin court decision, it is a valid judicial decision. I don't know whether it's been challenged in the higher courts by the Home Office. If they have,
recent, isn't it?
it is very recent. Yes, if they have, then until that this decision is overturned, it is still a valid decision. So if anyone has these type of scenarios where nationality application or passport application is refused based on that, then obviously they can make an application based on this case law. And I think because it's a valid case law, Home Office should consider this as a valid judicial decision and apply it in their circumstances.
Okay, that's good to know. Just coming back to nationality, someone's asked in regards to, for nationality, do we need to submit any documents related to employment? I know it's a generic question, but I think some people want to know. Employment documents do not really need to be submitted in regards to nationality, do they?
In terms of filling in the form, I think now there is a section with regards to employment as well. You will have to give evidence or at least dates, I think, of your employment. I think this has been brought in just to check whether the applicant was not in breach of the visa conditions they had previously. So, for example, if someone was a student initially and had specific or restricted work rights conditions, and they were obviously, if they were breaching those work rights, then
in terms of their hours allowed to work.
Exactly. So in that case, Home Office will refuse nationality based on previous breaches under immigration rules. I think just to cover these type of scenarios, they have introduced that section now in adult nationality form. Whether it is in other nationality forms or not, I don't know. If it's not part of the application, then obviously this information is not required.
Yeah. Okay, that's fine then. Some other questions that we're just going to take. A lot of people asking completely different things as to what we're discussing. One important question I'm seeing is quite interesting. If a child is born in the UK and parents are not British but grandparents are British, grandparents were not born in the UK, can a child apply for British citizenship?
It's a question regarding double descent nationality matters. This is something we need a lot more information to decide first. We need to know whether grandparents were nationals of British overseas territories or not. So there's a lot more information we require before we answer double descent questions. So if you have a specific scenario, you know someone, I think it's better to inbox us, email us, or raise these queries with our team, and we should be able to take further information and answer that question
for you.
It'll be very difficult to answer it based on the information we have. Generally speaking, if they don't qualify for nationality, grandparents are based citizens, they may qualify for right to abode category as well. So again, it depends on whether their grandparents where was the applicant born, what age applicant is at the moment, and also whether grandparents were citizens of British overseas territories or not. So all this information, once provided, we should be able to answer that question. It's slightly complicated, but if you can email us, we will be able to help you
with more detail.
With that question.
Okay. Not sure how long we have left, but in regards to one of our other topics that we want to discuss, we want to bring to people's attention in regards to the 7 years policy for children. In regards to people who have matters pending in the Immigration Tribunal, recently it's come to light that it can be reconsidered before the actual tribunal hearings even take place. Is that correct?
Yes, I mean, Home Office has introduced this. I can't say it's an official policy, but they are now reconsidering decisions, especially under 7 years policy or decisions where children are involved. So if you have an appeal pending, where application was made and it was refused on the basis, whatever basis, you have appeal pending, you can ask the Home Office to reconsider that matter before the appeals. We have had a lot of success recently in having these matters settled without the need of going to the tribunals. So if you asked your legal representatives to write to the Home Office, I think they would probably want to see more evidence. So see what the refusal is, and if you can give them bundles in advance for appeals, or provide them some further evidence, and ask them to reconsider the matter. We have had recently quite a lot of success in this scenario where we didn't have to go to appeal, and Home Office they have overturned their decisions and withdrawn their appeals.
Which is good for many people.
Yes, they will save a lot of cost as well as time, which is the most important thing.
Also worry as well, because everybody goes through worry during their immigration matters,
course, yes.
so it's good to resolve the matter quickly. Just trying to look for some of the questions. I'm just scrolling through any that you've seen that you want to pick out to answer.
I think another thing I wanted to discuss, which we had a lot of questions recently on, is decisions for highly skilled migrants, J1 general migrants, and the 3225. A lot of people have asked in terms of Home Office set up a committee. There was a first report, and we're waiting for the second report. I don't know whether the second report was published or not. I don't think it has so far. But in these type of matters, if these applicants or appellants can provide an innocent explanation as to why their tax issues, there were issues in their tax returns, for example. The first report states that appeals that were allowed, I think figure was 80%. I could be wrong, the figure was 80%. Where accountants have made a mistake in submitting tax returns. If that is the case, these appeals were allowed. So I would suggest strongly that go speak to accountants and make sure you can provide and if you can provide an innocent explanation, write to the Home Office before even your appeal is due to be heard, and provide them evidence to show why do you think there is an innocent explanation and you have not committed deception or intentionally provided any false information to the Home Office. And I think Home Office should be able to reconsider those matters. Again, we had success in doing so in the recent past, where these matters have been reconsidered and appellants did not have the need to go to the appeal. So from that perspective, I think it's better that we should contact Home Office in advance.
Good. So two people have asked a question in regards to the TOEIC matters. Two people have asked in regards to any updates on people who have been drawn into that catastrophe.
Yes, I mean, there is a recent decision of Khan. That decision was related to TOEIC matters where new type of Section 10 removal decision was served. Obviously, we had SN and others previously, November last year, where Court of Appeal clearly decided that if it is related, if you were issued a Section 10, you should have had in-country right of appeal. Issue was that applicable to those who were issued if their leave was curtailed under the Immigration Act 2014. Now this recent decision, basically what it says is it extends the applicability of SN and others onto those cases as well. So if you were refused and not given in-country right of appeal under the Immigration Act 2014 because of your TOEIC English language test, then in that case, obviously, same scenario will apply. SN and others will apply by the application of Khan and others, and you should be able to have these matters settled with the Home Office. We have a lot of matters of these sorts, and we have obviously proceeded with settling these matters with the Home Office, and you can speak to representatives, ask them to help you out with that. If you had appeals pending and same scenario applies.
Okay. So I'm just trying to look through any more questions. Have you come across any that you would like to answer?
Yes. I think there's a lot of questions regarding double descent nationality issues. As we said, we need a lot more information, and it'll be not possible to discuss it.
It's a case by case basis.
It's a case by case basis. So if you can contact our team, they should be able to help you out in detail with these type of matters. One thing I would like to say is that if we are not able to answer any of your questions, which we do miss sometimes, please feel free to
drop us in the inbox.
Email us. You can call our offices. We have a dedicated, experienced team who will be able to help you out. And also, we also discussed issues with regards to detention where parents were separated from their children previously, and we said that if you have any, if you know somebody who has faced this type of issues, we'll be happy to help them. Even if they can't afford legal fee, we'll be able to help them on no fee basis. And we have had a lot of interest raised in these type of matters. So if you have any type of cases or you know someone who has suffered, then please let us know. We'll be happy to help, because no child should be separated from their parents.
No, of course not. No, and yes, of course, leave your comments, and we will get back to you in regards to your other comments if we haven't answered them during the live show. We will respond back to you in due course to all the other queries. Otherwise, you can always drop us a line in the inbox or call us, and then we will get back to you and answer your queries. Other questions in regards to.
I think one of the questions that always pops up under EEA regulations is if someone has obtained leave to remain under EEA regulations, and for some reasons their relationship cannot continue or is broken down, do they have any recourse to any other type of visa? We know if someone is married to a European national, they can, and if their marriage lasted for 3 years and they fulfill other requirements, they can go for retained right of residence.
Of course, yeah.
But if you are an extended family member, that means your marriage is not registered legally, then in that case, unfortunately, retained right of residence requirement category is not open
to them.
Yeah, it's not open to them. This is the type of question we get all the time. And also requirements, if someone has a spouse or a sponsor who is a European national and they want to make an overseas application, spouse visa application or application to join their sponsor, under the immigration rules and outside of the immigration rules, are there any what are the requirements for these type of applications? For immigration rules, it is pretty straightforward. Under Appendix FM, obviously you need to meet income threshold of 18,600. If children are involved, then for first child it will be 4,000, then I think 2,200 per child after that, approximately. You also need to meet the requirements of genuineness test, the relationship is genuine. A lot of applications we see being refused are not on the basis that they haven't met the income threshold requirements or other requirements, which are obviously clearly laid out in the immigration rules. A lot of applications are refused because not enough documents are provided to show that relationship is genuine. So if you have any communication records, make sure you produce them at the time of making an application. Any travel records, for example, if you have gone and seen your spouses, and make sure you produce those records. Very important. Yes, exactly. And also you need to show that there is a valid there is a proper accommodation available in the UK, for which you need to provide property report from a registered state agent. If it's a rented property, then no objection certificate from your landlord. So these type of documents are necessary.
Coming back to proof as well, yes, I think a lot of people always take for granted kind of, a junk mail that they may receive a couple of years ago. They don't need it anymore, they throw it away. But if you're going to rely upon it at some point during your immigration matter, it is heavily important, especially if it has a date on it, if it shows that you are living together, etc. So it's definitely really important to always keep hold of documents and only kind of really throw it away when you are absolutely sure that there's no use for them, because I think we've come across that, haven't we, during our time,
quite
that a lot of clients unfortunately do not have documents, but
this is why I always tell them as a joke sometimes that everything you have brushed under your bed, lift up your bed and try and take all the junk mail out.
Exactly.
It may be useful in this type of scenario.
For sure, exactly.
Just to add on, if your sponsor is an EEA national, then obviously income threshold doesn't apply. If your sponsor is in the UK exercising their treaty rights,
that's all they need to do.
In fact, even if they are not exercising their treaty, even if they have just recently come to the UK and they in the first 3 months, they will be considered job seekers. So that means you can still make an application for the first 3 months. Then obviously after 3 months they will have to be exercising their treaty rights in different ways. For that you obviously need to show that it's a genuine and subsisting relationship. But other than that, there is no income threshold requirement in these type of scenarios.
So it's always important to really keep hold of everything and don't delete your messages, people, because that's also really handy. Okay, I think that's everything.
I think one more. We have received another question along the lines of what we were discussing. Someone has asked if the 5 years period as a dependent of an EEA national spouse of an EU national, from what date this period start? Does it start from the day you get your residence card, or from the date of marriage being registered? It's very clear under the EU regulations. Your time frame, 5 years, starts from the date you have registered your marriage, and not from the date you obtain your visa. So this is when your time period starts from, for 5 years.
Exactly.
Yeah.
Okay, great.
That's it.
So thank you very much for everybody's time and comments. We'll get back to any comments and questions that we haven't answered. If you want any in-depth advice from us guys, you can always drop us an email, you can call us, and all our contact details is being displayed below. So thank you very much for joining us, and we'll be back soon. Thank you.